I built this business the old-fashioned way. Hard work and a whole lot of spreadsheets.
Yeah, about that, I upgraded us to Odoo. Odoo puts everything we need, sales, inventory, accounting, on one connected platform. No more juggling systems, no more headaches.
So it all works together?
Exactly.
Odoo is the all-in-one business software that makes running and passing on a business easier than ever. Take your business into the next generation. Try Odoo free at odoo.com. That's ODOO.com.
Hi there, everyone, and welcome back to Real Estate Real and Unscripted with Nicole Miller. Thank you guys for joining us this week. I am very excited about this week's session. As you know, my goal is to really change this industry, the way that it is taught, practiced, and perceived. And the importance of every show, there's every show basically digs deep into some subject that relates to the real estate ecosystem. And so today we are going to have one of, I believe it'll be 3 series relating to the aspect of title when you are buying or selling a home. And what does that mean? What is all involved in it? And so we're going to be speaking today to an awesome attorney that I've known for many, many years, Donald Walters, who is a great real estate attorney. And our show today is going to be basically focusing on title through the lens of a seller. What are the things a seller needs to think about? What are stuff they need to prepare for? What happens through the transaction? Going through it that way. And then our subsequent shows are going to target the buyers, and then we'll have some conversations on another show because there's a lot to talk about. It's a lot, a ton. And I don't even know if we'll be able to touch on everything today on just the seller side. So, Don, thank you so much for joining me. I'm so excited to have you. And welcome. So, tell us a little bit about yourself, what brought you into this space in real estate law. And, I'm always big on what makes people different, like to be different, to, disrupt your industry, do things differently, elevate it, change it. So what do you think you bring to the table?
Well, I've been practicing law for 38 years in South Florida. My mom was a real estate paralegal, so I grew up around the real estate industry and understanding the process. I've always been interested. That was my dream when I went to law school, that I was going to do the same type of a thing and work in real estate law. Unfortunately, when I got to law school, the real estate market was on a very severe downslide. So that was really the only opportunities for me were in litigation. So I developed a litigation practice and specialty over 25 years. I worked in construction lien law, commercial collections, some landlord-tenant, and homeowners association law. So I was still always kind of just adjacent to the real estate practice, and I did continue to do real estate closings. But about 15 years ago, the circumstances changed. Most of my law partners retired, and it was just a chance for me to revamp my practice and go back to my passion and to take everything that I had learned over the preceding years and bring it into my real estate practice. And I'm a very detail-oriented person. I think that's why you and I get along so well. We're very similar in that way.
Fellow Capricorn.
Fellow Capricorn. Exactly. I know there's a sense that you do a lot of business with Capricorns.
I got to plug that.
And so I feel that, I'm a sole practitioner. I answer only to myself. And so I feel that what I offer is that 100% focus on the transaction that's in front of me, and just being able to take care of my buyers and my sellers to make sure that they're able to accomplish everything that they want with as little problem as possible.
Yeah, no, awesome. And that kind of brings up kind of my first, not question, but just comment and fact, right? So in Florida, we are title state. What does that mean, right? So you're a lawyer, right?
Right.
But would someone potentially sell a house in Florida without a title company owned by a lawyer? How does that compare to other states?
I mean, there are a lot of wonderful non-attorney owned title agencies out there, but there are a lot of ones that maybe, and unfortunately, if you run into a situation where you've got a problem during the transaction and there is not an attorney on staff, or it's not an attorney owned title agency, that title agency cannot represent you and they will not represent you. So you're then going to have to go and hire an attorney and spend additional money on this transaction to clear up these problems. So that's why I always recommend, whether you're a buyer or a seller, you should always have an attorney to represent you, because there are so many things that come up that need to be addressed, and they can come up without any anticipation of it happening. So you can do as much preparation as you want, but sometimes things come up. We've got a situation right now. The sellers put a new roof on their home, and we're in the middle of the closing process. And right after the roof was completed and inspected, the permits were closed, the roofer went out of business. And they didn't pay one of the suppliers, so the suppliers suddenly liened the property. And these sellers thought that they were doing the right thing and had prepared themselves and were getting for a smooth closing. And of course, now we have all these problems that have arisen. And if they had gone with a title agency and said, we're in Broward County, so the buyer selected the title agent. But if they had decided just to let the title agent do their documents, they would have then had to turn around and hire an attorney anyway.
So I'll talk to that. So we are in Southeast Florida. This is where this show is based. Palm Beach County, Broward County, Miami-Dade County primarily. And so in Florida, the tradition effectively is that there's a clause in the contract, or as is contract, it's the Miami-Dade Broward provision. And that basically means that as a buyer, you in Miami-Dade or Broward are picking the title company. You are paying the title insurance policy, and the seller is paying for the search fees, your title search, your lien search. The seller is paying for their estoppel. An estoppel is a document that comes from the association. It's kind of like your State of the Union of the association. It tells the title company what they have to do. And basically, in Broward, if you are a seller, then you have the option to select to have the title company selected by the buyer, which, by the way, if they are the title company, they are a neutral third party. Their job is to get to closing. They don't represent, even if the title company is an attorney, they're not effectively in the capacity of them doing the title, are really representing the buyer, unless they disclose that, and then at which point you would get your own attorney. But their job is to be that escrow agent, the neutral third party, to get you to closing. So as a seller, you have the option to choose to work with that buyer's title company that was selected, or you can hire an attorney like Don to be your seller representation. And when you are doing that, you are going to pay Don his fee, which is usually the same price as the title company is going to charge you to do your documents. So it's often a no-brainer in those cases. And on the flip side, in Palm Beach County, which is similar to a lot of other places around the state, right?
Most of the state, yeah.
Right? The seller picks and pays the title insurance policy. They pay the owner's portion of it. If you have a lender, there's a small portion that you're paying as well. There's a different portion there. But in the case of that, if you are a seller in Palm Beach County, you are picking the title company. If you are a buyer in Palm Beach County and you're paying cash, that title company may or may not charge you a fee. You can find that out in advance. And then you could potentially, if you were paying cash, have your own attorney represent you, like Don, in a situation like that. And you might effectively pay the same price you would have paid either way. If you're financing, typically that title company has stuff they still need to do for you, and they will charge you a fee. So if you wanted attorney representation, you could then have them, another attorney represent you and be a second set of eyes, right? So that's kind of the gist of because we talk in jargon, we know our thing. So I want to explain it to people out there, how that looks. And, ultimately, if you are a seller and you choose to have an attorney, it's a second set of eyes on everything going on. It's a great way to make sure that everything is going smoothly. And it also will help if, let's say, there is a problem. And now we have a situation where the buyer defaults and they don't do this or whatever it is. And there's only, your realtors are filling out a document that, ultimately in other states is not attorney states where you have to close with an attorney. The offers in these states, like New York, for example, there's the contracts drafted by the attorney. The realtor's filling out some sort, I don't even know, some form of here's our letter of intent or whatever, but it's not a contract. Here, the form that we're filling out is Florida Bar contract that's available to Florida realtors, and we are able to fill out blanks. Your realtor is not supposed to make stuff up and add anything to it at all, because that would be practicing law without a license, or it could be construed to be due to that. So if you're working with an attorney, or if your realtor has an attorney that's able to help you and give you the verbiage, or like, if your realtor's broker is an attorney and they bless the verbiage,
Right.
That's different. But I just can't make stuff up, right? And without having the attorney give us like the right verbiage, because at the end of the day, if you're a buyer and you're hinging on that protecting you, and it was written like crap and didn't have the things that needed to be in it, good luck, right? So that's basically how it works. So we are not an attorney state. It's a title state. So you'll find title companies that are owned by attorneys, that are run by attorneys. You'll find others that don't have attorneys at all. And you'll find others that are just title companies that might have an attorney that they reference, or maybe have someone on staff, right? So that's kind of the background when it comes to that. Did I miss anything?
No, they pretty much covered it all. Yeah.
So, ultimately, if you are a seller, I always recommend that you have representation. You could use anyone I recommend. You could use whoever you want, but it's good to have that second set of eyes. So many things have been caught. I mean, I've so many things. So Dawn, here today, we're talking about kind of like the seller's role with title, be it if you're in Palm Beach or Broward County, what are you looking at as a seller? What do you need to prepare? And so, basically, what would you say are some of the most important things a homeowner should understand about this process, right? They're going to sell their house. What are things that might come up? Like, what's the picture for a seller? Mr. Seller, I'm sitting here and I'm selling my house, and they tell me, oh, we're opening the file with the title company. Like, what happens at that point?
Well, I mean, there's so many things that a seller has to anticipate when you're marketing and selling your property. The actual transaction is not only about selling the building and giving the keys. It's also about ensuring the title to the property. And so there's a lot of work that has to go into the process to examine title, to make sure that there aren't any liens against the property, to make sure that permits are closed, to make sure that violations are cleared, all these various things, that the ownership is properly vested, so that the person that's sitting at the table signing the deed is the person that has legal title to the property. So I think that, it's not only a matter of the listing agent coming over and saying, I think you need to take down all your personal pictures and paint the room. That's about marketing the property. But there are a lot of other things that you need to be prepared for before you go into the process. Do all of your homework to make sure that there aren't going to be any title problems that are going to come up. Usually when we get a contract, the closing date is between 30 and 45 days. Sometimes it'll be 60 days. But if it's a cash transaction, I've had buyers come in and say they want to close in 10 days.
Yeah.
It's sometimes possible. I mean, there are certain things that, if you're in a community association, we have to order, as you mentioned before, an estoppel certificate.
Or if you're in certain cities that their lien searches are 5 business days and they don't consider Friday a business day. We had one of those.
Cities are closed on Fridays, and so you start counting your days and you're into 2 weeks already. But yes, association has 10 business days to present that estoppel certificate, and sometimes they take every minute of that.
Yep.
So obviously, we can get title done and get a commitment prepared and be ready to insure, assuming that there are no problems in title. We can get that done in a matter of day or two. It's the other things that have to be done in the survey and dealing with other third parties that are providing services to us. But so it's a very relatively short period. So the last thing you want is to discover that there are unanticipated issues that came up, a lien against the property, judgments that have to be paid off. Do your homework before you list the property. And that's one of the things that I know that you as an agent offer that a lot of agents don't. You do all that legwork coming in so that, we're on notice at that point. Hey, there's something that has to be addressed. So that's part of it. Just making sure that if you've done any work on the property, that your permits are closed.
Your notices of commencement. So
notice commencement,
speak to that. So.
Under the construction lien statute, when you record a notice of commencement, which is required for all improvements over $2,500 where you're pulling permits, it's good for a year. And that notice of commencement is a notice to the world that you're doing construction work on your property, improvements, and that anybody that provides material, services, or labor on that property potentially has lien rights against that. And everything would relate back to the recording of that notice of commencement. It's good for a year. So as long as it's out there and active, when we go and we examine title, we see that that's there. There are certain things that we require the seller to provide. An owner's affidavit. We need to get releases from the contractor and anybody that gave notice. We need to get contractor's final affidavits. If you can terminate that process faster, so if you're just doing a 2-week project and the contractor comes to you and says, hey, can you fill out this notice commencement and sign it? Ask them to reduce that time so that it's not a year. Make it good for 3 months. Make it good for 6 months, depending on how long you think it's going to take, because that is going to shorten the time that has an impact on your title.
So that makes me think, I mean, so many things are flying in my head, like this, it's crazy. But, one thing that brings to mind is I can't tell you how many clients. So yes, so you said that I do the legwork in advance, and I do. I am insane. And so even this year I did legwork and something came up and I was like, oh, for the love of God, there was one permit that was there before the system even existed. Great, of course. And it was before my seller bought the place. So she got, shafted when she bought the place. No one told her, right? So I do a lot of that work in advance. And part of that is to see if you have any open or expired permits. So one thing, I'm just going to throw this out there because I met with a seller yesterday and she said, oh, I would have hired an AC company. They would have always pulled permits. And I said, no, ma'am, no. What? And she literally was like flabbergasted by the thought that her AC was installed without a permit.
Right.
And so I can't tell you how many times I meet with sellers and they're like, oh, yeah, I had done all this work and it was done and there are no permits. Or, oh, yeah, I had hired Joe Schmo Air Conditioning and they did a permit. And I'm like, yeah, I see. It expired 4 years ago. And then I try to find Joe Schmo Permit Company, AC company, and they went out of business during COVID after 40, right? And then now you're in a position where you have a permit that was expired. Most agents are going to put verbiage in their buyer's contract that addresses the handling of any open or expired permits. The contract in and of itself does not discuss that. It only lends to the seller having to provide you what you need as the buyer to take care of it yourself at your expense. Right. It does not provide. So a good realtor and a good brokerage will have that in their boilerplate comments at the additional terms, stating that the seller agrees to, at their own sole expense, to secure and close out any open or expired permits. Other ones will take it even a step further, and we're going to talk about that. Actually, I was supposed to be at my next that I'm interviewing somebody helps close out permits. And basically what happens at that point, right? So an agent will put in the contract that the seller is responsible for not only closing out any open or expired permits, but closing and making right any work that should have been permitted that was not permitted. If you're on the seller side and you sign that, God bless you, you're in big trouble. So you want to make sure that your agent is understanding and reading and you're understanding that, because there's no way on earth my sellers will ever sign that. Right. We even provide a permit history form so they could see we've checked everything. So we'll check. So going back to what Don was saying, they'll check and see lien search, see if there's any open or expired permits. You don't want to be put in a position where, let's say you did your roof, you had this permit, and you forgot that they didn't close it out. Life gets in our way, right? I even did work and I had it in my calendar, make sure I checked that it got closed out, right? And you don't realize that it was not officially closed out. And now you're in a position where you're chasing down a contractor to get the closure of your notice of commencement because it was within that year. And you only find that out 2.5 weeks into the contract. And now you're trying to chase down Joe, the guy, and you're not getting anywhere. In a shortened period of time. So one thing that I do challenge the agents out there to do is that, and it's all so simple, and I teach classes on this as well, but go in, there's a website, there's an inspector out there. I'm not going to share it on air here, but there is an inspector out there that has an aggregated website of every permit website that is available. You have to log in and create an account. It is gold. I found it this year. Otherwise, I was manually doing it. But this year now it's opened up everything. You can go in there and you will see every city, and every city that's digitized online is on there. Remember that there might be before 1988, before 2000, they had a different system. Keep that in mind. But if you go in there, you're going to check those things in advance. Like when you take the listing, right? So then if you find out that your seller has an expired permit for a roof, happened to me 3 times, what are you going to do when you find that out literally 3 weeks into the sale?
You're going to get a permit expediter.
You're going to get a permit expediter. They're going to have to do it
and pay money for it.
And, and that's the other point I was going to say too, because we're talking title. So just to kind of dispel things that go out that's been spoken about and other agents will say, permits being open or expired are not a matter of title.
That's correct.
So when an agent will say, oh, we can't close because it's permit in the title. No. Right?
Right.
So
correct.
permits are not a matter of title. So ultimately, how do you cure that? You can hold back escrow. You can have it done before you close. You can wait, depending. There's different, nuances to the certain situations, but it's not necessarily going to be a reason you cannot close. For example, my seller closed 20 years ago and inherited one as well.
Right.
So,
and the worst ones are the ones that predated your client's ownership of the property. And that happens all the time. You find out that there was a permit for her. I have one now. The sellers have owned the property for 20 years. 25 years ago, the prior owner put hurricane accordion shutters on the house and never closed the permit out. Well, it was just a matter of going over to the city and paying a fee because, of course, the city always wants to get their fee for that. And then they came out and inspected and they closed the file. Thankfully, the shutters were installed properly.
Yep.
I don't know how much of an investigation the city did, but kind of depends on the city. Some of them are very, very tough, and they'll go in there as if it had just been installed. And
you'll need records. You'll need the records from the records department. You'll need the NOAs for those. I had one with a buyer. They did not install them with permits, and they were impact windows. They had no etching. They had no labels. They were not Florida rated.
Yeah.
They weren't. So they tried to cure it after the
fact. Code changes
fact.
all the time, especially when you're talking about hurricane type things, windstorm things. The code changes all the time. So what you did, solar panels. Solar panel code changed about 7 years ago, and solar panels that are older than 7 years do not meet current code.
Right.
So if you have to take them off to do a new roof, you're not going to probably not going to be able to put those panels back up on.
Or if you have to cure a permit,
right,
they're going to have you cure it to the current standards.
Exactly.
That's kind of the little caveat that kind of bites people too. So so basically those are things you want to look for. So
and it's such a simple thing because, like as you said, there are websites. Some of these city properties used to be unincorporated. I'm speaking specifically to Broward. There are a lot of unincorporated areas that have since been assumed by a city, and so you have to go back and look at the county permit records as well from the date before annexation. But it's a very easy process to go in. You can type in by folio number. You can type in by address, by permit number, whatever information you have, the former owner's name, your name.
Yeah.
There are different ways to search.
I swizzle that, and I have a new assistant, and we were talking about that literally as I walked in today. And I had shared with her, make sure that you're swizzling it all those different ways because you'll have it where it didn't go, especially like the condos. They're horrific. They go under either the lowest value of the stack, the lowest number. It goes under sometimes the owner is the association. They don't put it under the person, and they come through as like a tenant, but you can't search by the tenant name. Right. You can't search by a unit name. So those become a little bit dicey, but just something to kind of keep in mind that you want to get ahead of. And so from the respect of the NOCs, if you know that that's something that you're doing, you want to make sure that you're on top of them to get that release, and that release gets recorded. And then you're good to go. But that's something that's super important. And then touching as well on liens and things that become liens on your property. One thing that we went through recently, personally, right? Like I actually, in my history of my transactions, in one of my houses, I had a refi. And when I went to refi with another situation, the lender said, you have 2 mortgages. And this was before I was in real estate. And I was like, I have 2 mortgages? No, we closed the first one. And they're like, not according to public record. And, at that point, I was like, oh, gosh. So one thing that I do as well for the sellers is I will look in the county records. I will search their names. I will search each other's names and do as much as we can. There's also a way you can get the legal description in there so you can see that it matches to the house. There's multiple ways. So I exhaust options so that, and I found a handful of them over the years. I had a seller once, she refied and her original lender was Wachovia. And then it was like, well, how do you get that satisfaction, right? So you're refining and you're moving on to another lender. And part of that process is a satisfaction, and that has to be recorded. So try to get that within a week and a half before closing from a bank that hasn't existed in years, and you're trying to figure out who serviced it last. Right. And that was a disaster for her. And it wasn't because we did it when I took the listing. We didn't do it when we got to that point. Right. I sent her on her merry way to figure it out, and she did, and it took weeks. It was, how it is. We can't even get payoffs.
You have to get a head start on that kind of stuff.
Yeah.
So, and the thing about public records, sometimes you're not going to get as complete a search if you're just doing a public record search as you will when we do a title search.
100%.
Title, a lot of things are indexed to the legal description, and there's not a clear, easy way to search using the legal description in the public records, or they maybe perhaps misspell your name, and so you don't see that something's in there, or they hyphenate it, or they take a hyphen out, or something. There's something that doesn't you don't anticipate that that's the way that that's been indexed, and you go to search using your name and nothing comes up, and then we do the search and we've done it based on a lot of other identifying characteristics. There it is, and so. Right. But yeah, definitely get that's another thing to do before you're going in. Take a dive in the public records, see if you can find, because there could potentially be judgments entered against you. And there may be and you'll see sometimes judgments that are entered against somebody of a similar name.
Yeah.
And I know that you have intimate experience with that as well. Sometimes not so
not
similar,
even similar.
Not even really close.
Not even really close.
But and that's addressed with an affidavit at closing. That's not something that you have to satisfy. You just if that's not you, you don't have to worry about that. But if you could potentially be you.
So what if it is you? So I have a situation, right? And we have a lot of sellers, and we have a situation, and it came up, and this was as a byproduct of probate. So I couldn't do any research before, because before I didn't even know my sellers. And something came up, and there's a judgment of sorts, right? And a bunch of things came up on all my files, and they'll say, "Hey, is this you?" And they know that's not me, and look at the birthday, and you're like, "Okay, that makes sense. It's not me." But then, what if it is you? What if it's a bankruptcy? What if you have a judgment on a bankruptcy or something like that? There's certain ones that.
Hopefully, with a bankruptcy, if the bankruptcy has been taken to completion, then so there's no discharge, so there's something that has to be addressed. Yeah, I mean, then you're going to be doing some negotiating to get a release and satisfaction, because when we get our title work back, it says that you either need to get a release and satisfaction recorded, or you need to establish through reliable evidence that is not the debtor.
Yeah.
And then they can sign an affidavit. But many times it shows up, and people maybe even forgot about it. They didn't pay a credit card when they were in their 20s.
Yeah.
And there's a $300 judgment from Macy's, or actually from Burdines or something, that now is owned by Macy's, and it's been sitting there accruing interest for the last 35 years. Well, it's not going to be. Thankfully, we have enforceability. Some periods of time that things can be enforced. But let's say it's 15 years ago. And it's been recorded, and it was properly re-recorded, and it's got all the badges that it has to have. You're going to end up having to negotiate that.
Yes.
So
now, I've had multiple over the years. Many of these things come up. It's I think one thing I always say is to be prepared and to do things in advance and to know. So what are some of the things that a seller can do? I know we were talking briefly earlier about so as a title company, they'll reach out and say, "Hey, seller, do you have your title insurance policy?" Right? So speak a little bit to that. And if they don't, and the reissuance, and what does that look like?
Well, I think, that's always been a standard. It was always, we rely, when we issue title insurance, we go back to a base of title, which is probably going to be when you purchase the property, and you have a title insurance policy that was issued when you purchased the property. So we can start at that point and move forward. And I think now that we've got a lot of computerized research, it's less important to have that base policy, but it's always nice to have it there, because it kind of gives you, and not to get into too much of the weeds here, but when you get a title insurance policy, it's going to have certain exceptions to coverage, which would be your plat, easements that are on the property, maybe some agreements between the developer and the city, or the developer and a utility company. There's going to be a lot of things that it's subject to, declarations of associations, restrictions, things like that. So that's always nice to have all of that, to be able to look back and say, okay, this is what runs with this property, and it's a good starting point. But with computerized research, if we don't have the prior policy, the owner's policy, it's not as difficult, but it's
because you're starting over, right? So if you don't have it at all, you're starting over.
Well, now an exception to that, and because I practice primarily in Broward, it doesn't impact me so much. But if you're a Palm Beach County seller and you're paying for the title insurance, if you bought that property and have an owner's policy that's less than 3 years old, you're going to get a reissue credit, and that's going to substantially save a substantial amount of money on the cost of the policy.
I will plug in too that you don't have to just be selling your house to benefit from that reissue policy. Yeah. If you are refiing, and your lender that you call and they're like, "Oh, we're going to refi," and the lender actually picks the title company for you, because they don't really advertise that you can pick your title company. And the next thing you know, you got closing costs, and you don't know what you're reading, and you're paying for a new title insurance policy, but you bought you bought the house and it happened to me when I refied on something and I got a HELOC and I was like, what is this? Like, you could see that I bought it a year and a half ago. What do you mean? And I'm like, what do you mean? What do I mean? There's a reissue policy on it. You get my, so it could save you thousands of dollars. So it's not just in your sale. If it's less than 3 years, you get a discounted rate. And that's very helpful sometimes. Keep in mind that if you are refinancing or plan to, because I feel like that's going to be shaken out maybe with some, as rates go down, hopefully, just keep that in mind that if you did have the house purchased less than 3 years, remind them, send them your policy.
Well, for a refi, it's lifetime of ownership. So you can get that reissue credit for as long as you own the property.
Yeah.
It's the 3 years is the limitation is on when you're selling the property. If you're paying for the title insurance.
Oh, lifetime as a refi.
Lifetime for the refi.
Oh, okay.
If you're issuing a new owner's policy for a new buyer.
Gotcha. Because the title company that they originally picked didn't even gather that. Like they just went and they gave me the quote of the regular. Okay. Yeah. And they caught them. They didn't.
And to get a little further into the weeds, title insurance is a regulated product in the state of Florida. We have what's called promulgated rate, and it's a book that tells you every $1,000 increase or in the insured price, whether it's purchase price or loan amount, and it tells you exactly what the premium is, and so that is your promulgated rate. You can charge more than that as long as it's disclosed. Most people come in right at promulgated rate because there's so much competition. So yes.
Oh, I didn't know that they could charge more than that.
As long as it's disclosed, you can.
Yeah. Okay. All right. Interesting. So I was going to ask, is there a shopping, can you shop these things? Right. So there you go.
And again, if you're getting a mortgage, you're going to be getting a second policy that insures the bank's interest in the property. And we have what's called a simultaneous issue credit. And it says that you can issue that second policy for a premium of $25. And that's what my firm charges. We don't upcharge that, but it's pretty standard to see that that's upcharged to $200 or $250. And that is, as long as the agent remits the certain percentage back to the state, they can charge what they want. So that's the promulgated rate on the reissue credit. The simultaneous issue credit for the loan policy is going to be $25.
Right.
Anything you pay for that over and above is just been added on by your closing agent.
And then as far as, so title search, lien searches, like title search, I think in the contract, right, it has a maximum.
Yeah, there's a blank, and it's never.
There's a blank if you fill. Yeah, so if you leave it blank,
it defaults to $200. Again, it depends on your title underwriter and what they charge. My title underwriter charges me $125, and that's what I pass on to my clients. I certainly am well within my right to go up to $200 if I wanted to. I don't do that.
Yeah. And then so as a seller as well, like one thing I'll tell my sellers is, if the buyer picks a title company, I usually will tell them, I will reach out to the title company and I'll ask them what their seller settlement fee is. And I'll get back to you and you can make a decision if you wish to hire the attorney. They have the choice and the right to do whatever they want. Exactly. So I'll get them that number, right? But if the sellers, if the title company is giving me a number that's the same or more than any of the attorneys that I work with, why not? So you can.
Why wouldn't you? Because
you're literally getting an attorney for the same price.
All you're getting is document preparation from the title agency that's preparing your docs.
Yeah. So, there's a lot of great title companies and there's I'm not at all to be construed that I'm like trying to belittle anyone. I work with a lot of great ones. But I've seen through hundreds of transactions how it is very, it's helpful. Yeah. It's helpful to also have like a second set of eyes.
Sure.
So, for sure. And
if you've got a title agency that is having to draft something, having a situation where there's perhaps an escrow agreement, they can't draft that escrow agreement. And so if I'm in the transaction, I'm always the one that they say, hey, Don, can you draft this for us? But what if they're doing the docs? What if,
or a limited POA?
Yeah. I mean, there are a lot of documents that come up and they're only allowed to draft a limited number of things that are incident to the issuance of title insurance. They can do conveyance documents and bill of sale and things like that. But they really should not be doing anything else.
Right.
Certainly not escrow agreements, certainly not powers of attorney, things like that. So it's good to have an attorney involved in the transaction because there's not that same restriction. We're actually practicing law, and that's the thing that they're not allowed to do.
Right. No, for sure. What are some considerations now, post-Surfside, condos? Like, what are some things that you're seeing that are coming? And I'm going to mention a few things too, because I've had just everything hit at me the last couple of months.
I'm a glass half full kind of guy. So I'm optimistic that the worst of the condo situation is behind us.
Yeah.
We have, the condo market's a mess. There's no denying that. And we can see that in pricing. We can see that in inventory. I mean, it's a whole different market than the single family home market. It's like two sides of, two completely different markets. But as everybody knows, sadly, the Champlain Towers in Miami-Dade County collapsed due to a lack of ongoing maintenance, a lot of deferred maintenance. And it's very common in condominium ownership. And the smaller the condo, the more likely it is that the association hasn't been adequately collecting reserves. They may not have reserves at all. They may not have been addressing a lot of the ongoing repairs that need to be done, especially in multi-story buildings. And so there are potential issues that are just festering that nobody sees and nobody looks into. So after the collapse, of course, the legislature, being reactive, went back and passed a number of new statutes that address requirements of these associations to have adequate reserves, to do integrity reserve studies, structural integrity reserve studies, to ensure that they've got money in a correct amount. They just can't guess that, in 10 years, I'm going to have to do this. I'm going to have to pave the parking lot. No, we want to know what structural things you have to do to the property. When do the balconies have to be, taken down and reconstructed? When do you have to come in and handle some of the structural steel and things like that? But the problem with that is that a lot of these associations suddenly had to do special assessments to get their reserves up. At the same time that was happening, insurance premiums.
I was going to say, it's like a perfect storm.
So it was a perfect storm. We had all this situation where and so a lot of that is behind us now. We're a number of years into this. All of these condos that were constructed, it started out with buildings that were older, certain age, that had to do their milestone inspection reports, they call it. That's the statutory term, where they would bring out structural engineers to inspect the property and see whether there are any issues that are arising right now, and to give estimates about how the lifetime expectancy of certain other structural issues in the property. All those condos, anything that's 3 stories inhabitable and up, has to have those studies done, and they have to be done 20 years after construction if you're within 3 miles of the beach, 30 years of construction if you're beyond that.
Right, and it used to be 40.
Yeah.
It started at 40.
At 40.
So some of these condos that were like at 32 years, we're chilling, we got some time, and then this came.
Suddenly this came, and now
we got to get it done.
These are very, very expensive. So now you're being told you have to have, your full reserves, and you're going to bring in a professional company that's going to examine what your anticipated expenses are and tell you how much money you have to have in reserves. And if you're starting at 0 and you need to be at $10 million, you're going to have some special assessments.
Or if you're starting at 0 and your roof is due to be changed out in 3 years from now, is a very different feel on a monthly basis than if you took 20 years to reserve that same amount.
So a lot of these associations just kept kicking the can down the road. And now that it's time to pay the piper, to use the term. So what's happening now, and I think, is that condos will very soon be more fiscally stable than they've ever been.
Yep.
I think that they are doing the proper studies now, that they will anticipate all the expenses that could potentially come up and be prepared for that. And also, we've seen some changes in the insurance market, so premiums are starting to adjust.
And a lot of the work that these buildings and even houses buildings are doing are helping their insurance.
Right.
So it's a different number that you're getting from your insurance when you have a 35-year-old roof that's
and also could be increasing your property value.
Yeah.
Because now you've got new balconies, you've got new catwalks, you've got a freshly painted building and a freshly paved parking lot and a refinished pool, and all the things that had been deferred are now being done. And so it could potentially also be increased. So I like I said, I'm very optimistic about the condo market. We're not quite there yet, but I think we're on the path to a healthy condo market. And it's always, there's always a demand for people moving to Florida, and that's a very maintenance-free way to live. If you're in your retirement years and you don't want to have to be mowing a lawn and cleaning a pool, move into a condo.
So so that brings up, I was going to say, we're seeing it reset the baseline, right? So back years ago, I'd have people call me and be like, I want to move to a condo and I don't want the maintenance fee to be too high. And I was always like, well, what does that mean? $250, $200. I'm like, so let me explain. If it's $250 or $200, when you have a roof that needs to be done, God himself is not throwing it on for you. There's a shared ownership. So one thing, pushing back a little bit on what you said, not in any way other than a segue on it, it is maintenance-free living. but you are effectively all
Paid somebody else to do the maintenance.
Exactly.
You're not
right.
clean
So
yourself.
you are all sharing in this ownership, right? And so even like in the legal description of these condos, there's like percentages of the ownership that you have, because you don't just own your condo, you own everything that is on that property. So at the end of the day, when the chiller tower goes down and that needs to be replaced, when they're redoing this and that, when there's an issue with the pavement, when there's an issue with the pool, you are, 400 units in that building, you are 1/400th, depending on how they calculate it on square footage of that ownership. So that bill, exactly. So what I, urge people to do, if you're going to be buying in a condo, be smart. Join the meetings. No one said join the board. I don't join boards. Like, that's too much. But join the meetings. Read your minutes, right? So a few things like, what should a seller be aware of?
Well, you and I have talked about this before, and it's a perfect point. One of the things, if you're selling a condo, we have changed the contract over the last couple of years. There are a lot of documents that now have to be presented to your buyer, and it's not just what it used to be, which was the articles of incorporation, the declaration, the bylaws. They have frequently asked questions, things like that. Now it's the milestone inspection report. It's the structural integrity reserve studies. It's the minutes. It's because you want to know if there are pending special assessments. So there's a lot of things that you have to be prepared. So if you are thinking about listing your condo, make sure that you've got all that. The association sends you all the notices of the meetings. They send you the minutes. They send you the agenda. Hold on to those. Gather those, because you need to present 12 months of those to your buyer.
Right. And so one thing that I share with sellers, and one thing that I think agents have not quite gotten that memo. It used to be that you had 3 calendar days
Right.
to review these documents. And there is a receipt for a form or receipt that says that you acknowledge that you received them, and like that countdown starts, right? Now you have 7 business days, which makes a lot more sense. Who's going to review all those documents? And most people don't review them, but you should.
You should.
And the realtor's job is not to review them. Like, we're going to help and get you those things, but there's no way that we're able to review all that stuff.
And it's 7 business days from the receipt of the last of the.
I was just about to say that. Yeah. So
the clock is starting much later now.
So as a seller, if your realtor, when you are selling a condo, did not make it abundantly clear to you how important it is that you get every single one of those darn documents, and they have them so that when they go under contract and you sign the contract and you agree that you're moving forward and you're effective that date, I send them back the confirmation they got the documents, because they get a Dropbox file from me and they need to send that back.
Right.
Like on that day. The old rider used to have a field that you'd be able to populate. I used to do that. They got rid of it, which is annoying, but I used to put the date on there. We'd initial it, and then the buyer had to initial it so that the contract in and of itself was effective.
Right.
Like, because that would be an initial that was open. But you are being given a severe disservice if your agent does not comprehend that assignment. And I will give you an example. I was under contract with a buyer. I've been asking for these docs. I was asking. We are 2.5 weeks in. They're getting them. Don't wait until you're under contract to get these documents. You just bought your buyer an infinite inspection period.
Right.
Y'all are so worried.
Out of the contract at any
Y'all
at
are
any
so
time.
worried about the inspection period and, oh my God, and the loan commitment, and good luck, because the contract itself says that if those documents have not been acknowledged to be received, buyer can walk up until the day of closing. Okay? You literally just gave them a blank check to move on.
And it's a lot of these condo associations, they're in big communities. So you'll have your building or your pod, but then there's also a master community association.
Yeah.
And so I had a buyer that was in a transaction, decided he really didn't want to close on this transaction in a condo. And they had only given him the documents for the specific condo association, but not for the master association. So
get him out.
Right before the closing, we were able to get him out, and he got his deposit back. And they fought it because they thought, well, no, we produced everything. No, you didn't produce the master association documents. That's also required under the contract.
Yeah, we walked them out. We actually discovered something that came up that made the news. And it wasn't anything we were able to find. Like I checked public record I literally checked court records on the condo. We knew the litigation they were under, whatever. And, something happened and the buyer was freaking out because they're like, our inspection period is over. We're paying cash. And I'm like, no. I got a card in my pocket.
Yep.
They never got us all the documents. So if you are a seller, please, sometimes you also, depending on the size of your community, and they're just, they might not even be the size. I've had ones that were smaller that just had their stuff together. You might have a portal, and that portal will have a section with documents. And usually when I take a listing, a lot of my clients in those condos are probates and I'm helping children. So I'm usually like logging in, we're getting it all the system, helping them, and we're getting all those documents. And now I have everything. And if there's anything missing, we'll be emailing the association, hey, please send us the SIRS report. And what we see on the website is not updated, blah, blah, blah. The latest meeting minutes. Have you really not had a meeting since February of last year? Yes, correct. You have not had a meeting. So then I'll take a screenshot of that and I put it in the Dropbox folder. There's no meeting, it's all there so that you as the buyer are getting that information. But as the seller, if that's not happening, and Don, that's not happening. It's not happening. No, and it irritates the heck out of me.
You raised another good point is sometimes it's your children that are selling the property after you've passed and they don't live in your house. They don't know where you store your paperwork. Mm-hmm. They still have to gather this information as the sellers if they've inherited the property. And so keep a good file for when you're gone. So,
yeah.
You may, at that point, it's too late for you to tell your kids, oh, I've got, the last 12 months of meetings and minutes and everything. It's in that drawer in a folder, or, you have all that stuff set up so that your children don't have to go chasing that down after you're gone.
Yeah, for sure. No, I do a lot of chasing. I do a lot of sending listing agreements to associations and, trying to, and like sometimes when you pass in these communities, they want the children sometimes to apply. I'm like, they don't need to apply. They're selling the place. Like, can we and so we have to go over all these hurdles. So if your agent is asking you for these things and it seems like they're annoying, that's because they're doing their job.
Exactly.
And if they are not asking you for these things, you are going to leave yourself open, and it's not good. So that I think is the biggest thing on the seller side, because it's an out. It's an out, and I've used it a few times. So yeah, super, super important. Other things too, coming to my mind as far as like condos. You have condos. We've dealt with our share, right, together. Condos. What type of stuff will trip up the title of a condo? That comes up in all of our experiences of fun times.
So there are, as we mentioned, there are a lot of associations that have been required to do these milestone inspection reports. They've been deferred maintenance. And so sometimes that can result in a code enforcement violation. And that code enforcement violation could then turn into a code enforcement lien. The association gets flagged for painting, paving, whatever, structural issues, and they don't have the money to do the work. And so they can't rectify that violation right away. And at some point, the city then converts that to a lien. That's going to come up. And even the code violations are going to come up in title work. Mm-hmm. And so as a closing agent, we're going to be looking for that to be handled, for that to be resolved. There are some cities that will give you partial releases. So you can release your particular unit from the effect of that lien. Some municipalities will not do that. So then you have to put pressure on the association to get the property in compliance and get the lien paid off, and it sometimes can kill your closing.
And that kind of goes back to this whole shared ownership concept and knowing what's going on.
Right.
So I've had, God, I can't even tell you how many of them. Oh my God, so many of them where my sellers are like livid that like the association put them in this position. I've had communities that couldn't sell for a year and a half.
We're all very, very busy. Everybody has a life, and people, even a lot of these retired people that don't have a 9-to-5 job have other things that they're doing. But it's usually one night a month to go to a board meeting or to an association, or one night a year to go to a membership meeting. And this is a big investment that you've made, and you want to make sure that these people who are stewards of your investment, that they're doing their job. And so be informed. Go to these meetings. Yeah. It doesn't cost you anything to go to these meetings.
Yeah.
And I've served on a number of boards and associations in communities where I've lived. I've been the president of boards in communities where I've lived. And I'm always shocked that, you could have a community of 700 homes and you've got 6 homeowners sitting there at the meeting.
Yeah, and they don't even have enough sometimes for a vote.
Right.
Sometimes they're literally like,
they can't even for a membership. Yeah. So it's, it's hard enough to get board members, but to get members to show up, that just to to be involved? I mean, just to hear what's going on.
They show up when there's a letter where there's an assessment, and then they come and they get angry and they blame the associate. I mean, I'm talking from experience. I go to these meetings because most of my sellers are not here, and it's like and then they're upset why this happened and why the association stole all their money. And it's like, no, hon, they didn't have any money. Like, y'all didn't reserve for a very long time. Like, that's why you're getting an assessment. So, be informed, because it's not just the maintenance free aspect. Like, you are all shared, and you're trusting these people to, make these decisions. So be active, be involved, or don't be surprised if it comes back. And another thing that comes up too, right? So part of the search, part of the things you do, the title, the lien search, right? And then you have the estoppel, right? So that is with respect to a condo or an HOA association. And, they will come and some associations will do an inspection of your unit before you close. To make sure you didn't, grant the new buyer a problem. Some communities will do a walk around your community, around your house, and then suddenly, next thing you know, you need to pressure clean your roof, and that comes on Dodd's estoppel, and then we have a code violation that comes out of that. The estoppel will tell them if they have to convey any keys or things that they would have to pay if they didn't convey. All these little things that come up as far as the it'll also say if there is any like litigation or anything like that, or if there's that comes up on a condo questionnaire. I know more so I'm dealing with that right now. But what are some of the things that come up, or anything I might have forgotten, like so assessment?
I think you used a very descriptive term before, but this is really basically just tells us what the state of the union is, what the state of the condo is. It tells us what the current amount of maintenance is, whether the the seller is current on that, or they're delinquent, or if they have a credit balance, what the anticipated payments coming up are. Sometimes we'll get them towards the end of the year that says this is what it is for the next 3 months, but it's going to change in January.
Mm-hmm.
And sometimes they'll have that number for us. They'll also tell us if there are any current special assessments, or if there are any pending special assessments, or if they've been talking about special assessments. They'll tell us whether the homeowner is in violation of any of the rules and regulations. You mentioned before whether the association is engaged in any litigation.
Mm-hmm. Or if the homeowner is engaged in any litigation.
Sometimes with a condo, we'll find out the storage locker, the assigned parking space, because sometimes those aren't deeded with the property. They're assigned by the association, and sometimes they'll change.
Right.
And we'll find out where the mailboxes are, and how much it's going to cost to get a pool key, and whether you need to be interviewed or have an orientation meeting, and whether there's an approval process. And so the estoppel is what we look at. It's our roadmap to tell us exactly how to clear all those conditions, all those requirements in our title commitment that relate to the condo association or the homeowners association or whatever community association it is, because we have certain things that we have to do. And that roadmap comes back to us in the form of the estoppel. We can say, yes, we've satisfied this, we've satisfied that. We can move towards closing.
Right. You had mentioned earlier about how, they make sure, like the title search, right? And they go through the chain of title. They make sure that everything was done correctly, every deed transfer. And if, let's say, I sold it in like an arm's length transaction to you, and it went through title, and it was, there was a title policy that happened with my transaction. So I'm saying this, and when I'm speaking about this, I guess I'll frame it by saying, like, as a listing agent, if you're getting a listing and you're looking at this deed, don't look at BCPA, don't look at IMAP, look at the deed.
Right.
Because BCPA, especially IMAP, does not usually have the names correctly, or has everyone if there's like a whole list of them. It will also have it a little strange, because depending on if it was like a remainderman, and it may not have, or sometimes I've seen it where it has both of them before it's even a remainderman. So look at the deed. And, speak to your title agent or title attorney and just like get some knowledge on how to read it. You're not practicing law. You're reading a document, just like the one you filled out. And if it says, Joe Schmo gave it to Jane Doe, and it, and that's the last deed, it was a warranty deed. It was on the MLS. It came with title, blah, blah. That's different than if you look at the chain of title and you discover that your seller had 12 different deed transfers over the last 15 years. And you needed to roadmap it on a spreadsheet with your title agent. That happened to me. And it was literally like, oh crap, I think we have a probate up here. And then we had to like literally figure out when she died to make sure that they broke JTRS before she died and not, I mean, after she died, it was like a complete disaster. So
the county recorder is probably going to record anything that is
anything
that appears to be legally sufficient.
Yeah.
The property appraiser then will review it to make sure that the grantor matches the name on title, and they'll do certain things. But there could be fraudulent deeds in the chain. There could be mistakes that they missed, or it could be back before the property appraiser was as diligent as they are now.
not fully executed, not witnessed.
Yeah.
And
And now we find sometimes we'll have a chain of 5 or 6 deeds with a bad legal description. And it's especially when you have a meets and bounds description, which is not, we sometimes we have platted property. And so it'll be lot 6, block D of a certain, platted area. But sometimes it'll be a range in township and it'll be a certain number of feet and degrees and minutes. And so you have this long meets and bounds description. It could be, 15 lines long of all these calls. And that has to close because they start from wherever the marker is on the plat and they go to what they call the point of beginning. And that's where the parcel begins. And then they give you all the directions and the time and the length until you close the property. Mm-hmm. And sometimes, because there's a lot of numbers and there's a lot of letters and there's a lot of degree symbols and feet marks and minute marks. And sometimes that gets messed up. And closing agents will often just look at the last deed to get the legal description. And if there's a mistake in the previous one that wasn't get caught, it transfers to the new owner.
right.
And the property appraiser now has software that they run these legal descriptions through the software to determine if that closes, if that properly identifies the property. And if it doesn't, then you get a curative notice that you have to fix this. And so sometimes you'll look back in the chain. So now when I get a file and I'm preparing a deed, I don't look just at the latest deed. I go back and find every deed in the chain, and I look to see if it's consistent all the way through, especially if it comes from a developer. Not that there aren't problems with developer deeds sometimes, but that's usually the most reliable.
Right.
And just make sure that there haven't been any mistakes that have been made going through. And that's more minutia than it is about what the seller has to do. The seller's not necessarily going to be able to find that themselves, but it's an issue that comes up.
And I bring it up because one thing I could say that I have had a lot of experience with what I call like generational homes, and where it's going from Sally to Joe and the cousin and the brother and the mother and the son, and then it went back to the mother and went back to the son, and there was a family situation, or just, your grandmother passed it on to your parents, passed it on to someone, and when they did the deed where they passed it on to their 2 kids, they did it as, tenants in common. There was no joint tenancy.
Right.
And then you come to me and you're the one kid left. And
guess what? You didn't get title to the property.
We need to get out the other half, right? Like I have experience like galore when it comes to this. So one thing I'll share just kind of out there, if you are a seller and hiring an attorney for your seller side, can start, before, right? Like, so if I have a seller that's in advance, and we've done this before where I've been like, hey, I just want to make sure, like, could you look at this and make sure we don't have a situation? And so, the seller's attorneys I've worked with in a few cases I've actually done in the last few weeks, we went in advance. I had one that with the title, I was like, good Lord, what did they do? Right. And we had to send it to a title underwriter to review. Yeah. And then we were able to, figure out the date of death. And then I found out, there 3 people could have joint tenancy. And if one removes themselves, the other 2 are still joint tenants. I literally became an expert. And if we didn't, I'm not conveying this to practice law, I'm just, it's facts. And if we didn't have that knowledge because someone thought that they broke all of joint tenancy and then someone confirmed, no, it didn't, and we would have probate for a long time ago. Right. So one thing I, urge sellers and owners out there is that if you have the need to transfer title, spend the little bit of money to have an attorney.
A title attorney.
Yes, a title attorney.
Divorce attorneys out there, a lot of wonderful criminal law attorneys.
A title attorney.
I don't know anything about criminal law, so don't come to me and ask me if you've been arrested.
A title attorney. And then, have them draft it because, I've had many a deed that turned out later into a probate disaster. And so saving a little bit of money ends up costing your heirs and you a lot more later. So that's one
of the things we can do. If you've got a really messy chain, we can do like a owner encumbrance search. You can't insure title based on that. It doesn't, we don't give opinions as to who owns it, but it identifies issues and tells us what potential claimants there are, whether it's a mortgage or a owner, things that possibly popped up that you didn't see. So that's a relatively inexpensive search to run, and it gives us kind of an idea of what we need to be looking for.
Yeah. I think sometimes it's good to get ahead of things, and the preparation helps a lot of the headache at the end.
A lesson, that's a universal lesson in everything that we do in life. There's no substitute for being prepared.
So is there anything that I may not have asked that you could think of that you burningly wanted to discuss or share?
I think it's very important who you hire as an agent. You need to, there are many, many agents out there, and they're not all the same. They all don't do the same amount of work. When you are listing a property, make sure that you sit with the agent and kind of get a good feel for their personality, for their work ethic, for what they do to prepare. It's not just about getting their commission. It's not just about quickly getting you to the closing table. It's anticipating all the problems that could be potentially coming up, so that you can have a little bit extra time to get them resolved. So it's just that's the and unfortunately, by the time a file comes to my office, generally everything's been done. They've already signed the contract. They've already hired their agent. They've already picked their lender. They've already picked their insurance company. I mean, we get the contract, and I would love to see it before it's signed. Thankfully, I work with wonderful realtors that I trust that do a fantastic job, and I don't have problems with the contract. But sometimes there's a new agent that comes to me and says, "Oh, here's a contract I'd like you to do the closing for," and I say, "Okay, first thing we need to do is go back and make some changes to get a legally enforceable contract that's correctly filled out." But so I just think it's all about, it's just this is a big field, and it's a big transaction, and it's probably the most important investment in your life. So take a little bit of time to make sure that you're bringing the right people in. And when you find a good realtor or you find a good title attorney, you're usually going to find a good team behind them.
Yeah.
So that you have a great insurance agent, you have a great lender, you have a great, roofing contractor or permit expediter or whatever. We all work with people every day that we like and trust. And I know many times I've gone to you and said, "Hey, I need a recommendation for something," and I trust everybody you refer to me because I know the way you do business, and you're only going to do business with people that do business on that same level.
People off real quick.
So I think it's really that's my cautionary thing is that this is a big investment, and it's a big investment for a buyer, but as a seller, you're getting ready, and a lot of times you're selling because you bought something else.
Yeah.
So you don't want that new transaction to be delayed or compromised because you didn't do your homework on the sale. So that's really it's my message to everybody: be prepared, do your homework.
I think that it's about knowing, and that's like the whole thing that fires me about this whole show is like knowing that it is a lot more than just that marketing piece. You're not hiring your agent because they're telling you the price that you want to hear.
Exactly.
You're not hiring your agent because they are giving you this marketing plan. You're hiring your agent because of all of this.
Yeah.
You're hiring your agent to have this, all this comprehensive, like the damage control, anticipating things. Like that's why you're hiring someone. The market has shifted. The industry has shifted.
Sure.
It's not that, glorified, like just salesy. We have data. Like you can't sell an overpriced property to a buyer. They know. Like there's a lot less to be said about that. The important stuff is all of what we're talking about, all the things that my show is, bringing to light and having all these pieces that you don't think about, because a lot of you guys don't. You don't think about all these things, and that's what goes into it, right? So
I've heard it from more than one of your guests. It should never be the number one issue. The number one qualifier should never be the price and going for the cheapest.
Oh yeah,
because you're going to get what you pay for.
100%.
You may end up paying twice.
100%. Yeah, no, wonderful. Well, thank you so much for joining me.
Thanks for having me.
I really appreciate it. If anyone wants to reach you out there, do you want to direct them to maybe like a website or?
So my website is dwalterslaw.com. The email address is dwalters@dwalterslaw.com. Social media is @DRWPA, and my phone number is 954-840-0494.
Amazing. So guys, if you got any gold nuggets out of today, Please like, share. The whole purpose of this is to really just drive education and knowledge because that is our superpower. And if you need anything, have any questions, want to bounce anything off of any of us, or looking for a seller rep or a title company, don't hesitate to reach out. And I really appreciate you all listening, and I will see you on the next one. Have a great day.
Too many tools, too much stress, and way too many bills.
Odoo replaces it all. One connected platform for every part of your business, so you can work faster, smarter, and for less. Odoo, the only software you'll ever need. Try it free today at odoo.com. That's ODOO.com.